Please be seated. I would like to invite the Deputy Co-Prosecutor to submit. You have 25 minutes left.
Thank you, Your Honours. Your Honours, I submit that my submissions today won't be as expeditious as the learned International Council and National Council, and they won't have as much flair. But I hope my submissions will convey more completely the fairness or the accuracy of what is required in terms of translations in the defence case. The prosecution joins with the defence, of course, in ensuring that this trial for the accused or the charged person, that it would be expeditious, or this process would be expeditious and fair. If a process is only expeditious, then the legality of the proceedings would be undermined. In terms of fairness, then, it really is a question of what is fair for this charged person, what is fair for this defence team in terms of being able to understand the case that's been alleged against them, or the investigation that involves him. That's a little more complicated or a little more complex than our learned counsel has put forward today. In short, the defence's position is that every document, every line of every document in the case file, no matter how large, must be in the language of the native language of the International Co-Council. It's submitted here, Your Honours, that is not appropriate. That has never been held to be inappropriate in any other court when Your Honours look at the jurisprudence, and we have identified that during our brief, in our brief. And secondly, it's not required, and it's largely not required because of the nature of this system and the systems that operate at the other tribunals. And that's a system of a joint defence team with multiple languages, with collaboration. And as a result of that, and as a result of the complexity of these cases, all of the courts have said collaboration is required in the defence, and not every counsel, nor even every accused, needs to necessarily be able to read every document that may be used against him, but he must understand it. And that's quite a different distinction. And to understand, of course, the defence counsel, as with the prosecution and as with the chamber, everyone has an obligation to collaborate, to maximise their skills, to ensure that each of our different roles are fulfilled. Your Honours, I will make 3 points. The first being that this charged person has all the documents he's entitled to in a language he understands. Secondly, the defence team, including the International Co-Council, is able to effectively represent the charged person. And thirdly, I won't address this point specifically, but if Your Honours found that there was any sort of violation or abuse of process, that the remedy certainly is not releasing this defendant. However, that's not the prosecution's position. The prosecution's position is that the order is legally justifiable and quite appropriately reflects the rights of the accused or the charged person to having a fair trial. I'll first briefly mention a point raised by my colleague about what it means, the term the working languages of the tribunal. You've heard the defence state in their written pleadings that working language means that every document must be translated in English, Khmer and French. That's not correct. The practice direction shows that that's not correct. 7.1 of the practice direction states that documents only need to be filed in Khmer and one other official language, not two others. Similarly, this issue has been tested, of course, at other tribunals that have faced the issues that you're facing today, and it's been held that working languages mean something other than the translation of every document into the three. If we look at the Yugoslavia tribunal that has the same working languages, French and English, the Delalic decision, which was confirmed in the case of the Zaric decision at that court, held that implicit in the concept of working languages is that all papers which are filed with the International Tribunal be in either English or French, not both. Your Honours, the law that relates to translation rights in these types of cases at other tribunals of similar complexities, as my learned colleague has said, relates more to the rights, or is focused more on the rights of the accused rather than the rights of counsel. And it's important, therefore, to ensure, in terms of a right to a fair trial, that the rights of the accused are upheld. Based on the international case law dealing with similar cases, during the pre-trial stage, whether it be in a civil system, a judicial investigation, or with a hybrid system of civil and common law, like at the other tribunals, where it's a prosecution-led investigation, the rights are similar. An accused is entitled to, when Your Honours look at the jurisprudence, a copy of, and at most, the introductory submission in the civil system, the notification of the charges, the indictment, the supporting material accompanying the indictment, the statements of all the witnesses that the prosecutors intend to call at trial, discovery material that's in the language of the accused, exculpatory material, and written decisions and orders. This list, or this composite list, taking into account the different systems, was first determined at the ICTY in the case of Lubicic and was later upheld in the case of Sechel. The pre-trial chamber of the ICC in the Lubanga case agreed with the ICTY when it ruled that an accused is not entitled to have all procedural documents and evidentiary materials translated into his language. The ICC held that the only evidentiary materials the prosecution is expressly required to translate are statements of prosecution witnesses. In the Lubanga decision, the court at the ICC, they considered the European Court of Human Rights jurisprudence on translation rights, including Ludicki and Kamasinki, which the defence cites in their appeal, and declared that nothing more than the above list was required. Our sister tribunals have held that providing a defendant with an interpreter is an adequate substitute for procuring the translation of certain documents in a language he understands. The ICC in Lubanga held that free assistance of an interpreter and translations of specified documents meet the requirement of fairness. This decision was upheld in the case of Chow. In the Rwanda tribunal, in the case of Muhimana, it stated that if the registry had difficulty translating documents, it could have them orally interpreted to enable the defendant to get a gist of its contents. Therefore, according to international tribunal jurisprudence, At the pre-trial stage, which is similar to the stage at this court, only certain documents must be translated into the language of the accused, and the provision of a translator to assist the accused to adequately protect his right to a fair trial. If we look at the case of this charged person to see exactly what he has received, to see if it fulfills that test of what he's required to receive in order to ensure that at this stage that he has the ability to have a fair trial. And my learned colleague has correctly pointed out that this translation order is not a final order, it's a progressive order that understands the nature of where the proceedings are, but also understands it's an order, or the rights of this charged person will change over time. They will change as he approaches the trial, and they will change when he's in trial. The appeal is about the appropriateness of this order, not about ultimately what he's required to receive at trial. Your Honours, in accordance with the jurisprudence, this charged person already has the translation of all documents necessary to protect his fair trial rights and prepare an adequate defence at this stage. In addition to and including what is required by the order and law, he has been given the following documents in all three languages: Khmer, English and French. He's been provided with the introductory submission, which is the primary document notifying the charged person of the legal and factual nature of the offences alleged against him. This is a comprehensive submission of over 100 pages, 55 of those being footnote references to the exact page in the evidence that supports that submission. That has been provided in Khmer, French and English. He has been provided with a detailed list of witnesses categorised according to the factual and legal elements they have knowledge of and could be expected to provide testimony on. This list, entitled Annex B to that submission, is 96 pages long, and it's in Khmer, French and English. He has been given a detailed set of 105 schedules comprising of over 1,200 evidence summaries of fully referenced statement excerpts from the introductory submission supporting material. Each reference, each excerpt, indicates the exact page or pages in which the evidence can be found in the original document. These schedules total 206 pages. Those schedules have been provided in Khmer, French and English. He has been provided with a document index entitled Annex C, which is a complete reference of every one of the 1,039 documents supporting the introductory submission, covering 55 pages. It contains all the identifying information for each supporting document, including a brief description of its contents and an opinion as to which aspect of the case it assists in proving. This annex, with corresponding electronic documents attached, has also been provided in a sophisticated analytical program allowing for an easier and faster understanding of the submission and the documents. Those documents have been, that index has been provided in Khmer, French and English. Your Honours, in relation to the introductory submission, it totals 616 pages of various levels of analysis of the introductory submission. It describes in Khmer, French and English in detail the prosecution case theory and the legal and factual elements of the case supporting the allegations against the charged person. This information allows equally the charged person and every member of the team, the defence team, the ability to understand comprehensively the evidence against him and therefore prepare his defence through the judicial investigation phase at this stage. The supporting documentation that supports the introductory submission, these 1,039 documents, 83% are in Khmer, a language the accused can understand, 10% are in French, another language he can understand, and 7% are only in English. There is more English, but 7% are only in English. That's as of 2 days ago. As the defence have said, Khieu Samphan is proficient in Khmer and French. Over 93% of the documents are in a language that the charged person can understand. Therefore, regarding the introductory submission with all of its supporting material, the branches of this court have ensured that even during the pre-trial stage, the charged person can easily understand the allegations against him. The remaining part of the case file, which is the judicial investigation that's happened since, contains about 2,683 documents, not the 60,000 documents my learned friend was referring to. I think he may have been referring to pages. But the 2,683 documents, 60% are in Khmer, and combined with French, about an extra 25% are in French, meaning that 85% of these documents are in a language that the charged person can understand. It'll be submitted in a moment. The charged person can also understand English to a certain level. If we look more closely at the investigation and look at the statements by the co-investigating judges, they've taken 194. 99% are either in Khmer or French. In fact, the translation reflects a policy of the OCIJ that as a matter of course, all of the statements taken from witnesses will be translated into all three languages. Your Honours, Khieu Samphan, through his counsel, in a document numbered C26I22 at paragraph 12, states that Khieu Samphan only understands Khmer and French. However, he seems to have a proficiency in English. A press conference in 1998 is one example of where it shows that he has a reasonable command of English. And I would just ask that the AV booth can play just a short segment of that video showing the proficiency of this charged person in English, at least to a certain level. If I can ask that that could be played now. Your Honours, this is a clip from 1998.
The defense lawyer, would you like to be heard?
Your Honours, I would like to once again thank Mr. President, but I would like to object this request for the play of this clip. Mr. Khieu Samphan has repeatedly said that he was actually acting as a symbolic role as the chairman of the state president, and then he was trying to speak English language when he was trying to express himself in English. It does not necessarily mean that he spoke English at that time. At that time, actually, he was trying to pretend that he spoke the language, but unfortunately, I don't think that he knows how to he knows the language. Thank you.
Monsieur Samphan n'improvise pas. Il a un texte que d'autres ont écrit et il est en train de le lire. Alors on peut inférer de là qu'il parle anglais comme un étudiant d'Oxford, mais c'est une interprétation un peu exagérée.
It would be an exaggeration to consider that Monsieur Samphan is fluent in English because he was actually reading out a text that was written by somebody else for him.
If I can just briefly mention, I know there's a shortness of time, and of course if the video is played, it would take up some of that time. If I could ask Your Honours at some point if you could review that video. It's been placed on the case file, and make Your Honour's own opinions as to his proficiency in English, unless Your Honours would like it played right now.
It's the pre-charge chamber's understanding that it is in the case file and that you make reference to the document in the case file, and you ask the pre-charge chamber to pay attention to that reference.
Thank you, Your Honour.
That's understood.
Great. And just to be clear, Your Honours, the prosecution are not saying that Mr. Samphan is fluent in English at all. We're just saying there's a level of proficiency that should be taken into account when determining whether, as a defence team, they have an ability to read or deal with English documents. Perhaps now if we move to the right that might attach to a co-counsel, such as the International Co-Counsel. Again, the prosecution submits the rights to translation largely concentrate on the rights to the accused. However, defence counsel that don't speak, that require documents in their native language, there are some rights that apply to them. In the Muhammana case before the Rwanda tribunal, the defence counsel, who was only conversant in French, requested to have materials disclosed by the prosecution in French and to have the registry ensure free translation of materials. After detailed consideration, the tribunal said 2 types of documents should be translated as a result of that request, English and French. In English and French, the party submissions, secondly, the evidence that would be adduced at trial. However, regarding all other documents, the court hoped that through fruitful collaboration, the defence team would work together to understand the contents of the documents. Similarly, in the Lubicic case, the Yugoslavia tribunal held that although the defendant could not understand all the documents in the case, at least one of the defence counsel is presumed to be fluent in one of the official languages of the tribunal and should be capable of fully participating in the proceedings. Like Lubicic's defence team, the Samphan defence team consists of 2 attorneys which are fluent in at least one working language of the court. Therefore, Samphan's team is competent to fully participate in the proceedings and present a reasoned and adequate defence. As of right, therefore, in terms of evidentiary documents, at this stage, there is no entitlement for the International Co-Counsel to receive documents in the language of his choosing at this stage of the proceedings based on international jurisprudence. However, any documents that he thinks he may wish to put in evidence could be requested to be translated. As a trial may approach, nonetheless, the International Defence Council, based on this jurisprudence, could receive translation of the evidence adduced at trial in 2 languages. In light of the unique rules at the ECC, this evidence would not be everything that's in the case file, but it would likely be a subset determined by the parties through their Rule 79.9, where it requires the parties to provide exhibit lists, and the trial chamber's lists of evidence it would like to put before the parties either in full or a summarised form pursuant to Rule 87.2. However, the assessment of the extent of that right would need to be taken into account many factors which are more easily and appropriately addressed at the trial stage of the proceedings. Your Honours, if I can ask to have 10 further minutes to finish, that perhaps might be an extra 5 minutes that was originally provided to complete the submission. Your Honours, I'd like now to turn to the duty or the obligation of the defence to cooperate with the organs of the court. The defence argue that this court is required to exercise due diligence in the conduct of proceedings, particularly where the charged person is in provisional detention. We submit it has. The Office of the Co-Investigating Judges, the Defence Support Section, the Court Management Services and the Office of Administration have worked tirelessly day in and day out to move forward with this investigation. Conveniently, the defence neglected to mention the duty upon themselves to cooperate with the organs of the court. Article 21.3 of the ECC agreement states that any counsel, whether Cambodian or not, engaged or assigned on behalf of a suspect in the defence of his or her client must act in accordance with the present agreement, the Cambodia law on the statutes of the bar, and recognise standards and ethics of the legal profession. All national jurisdictions have rules governing the conduct of lawyers that require them to act in an ethical, responsible and professional manner. In the ECC multilingual environment, the duty includes working diligently as a team to represent the client. Your Honour recognised this in your adjournment order on the 23rd of April 2008, when you stated linguistic and legal issues may be fully addressed by a team of lawyers representing a charged person. The alternative, of course, is if such collaboration with a team is not possible, is for the charged person to make a request for a new lawyer to represent him. This sentiment represents the jurisprudence of the Rwanda Tribunal, which stated that through fruitful collaboration, one counsel would be able to help the other to understand the contents of the documents. In the Katanga case, the pre-trial chamber at the ICC stated, it's the responsibility of permanent counsel to compose the defence team in a manner which will allow him or her to be properly assisted in the presentation of the case and effectively protect the rights of the accused. At the ICC in the Lubanga case, they also emphasised that the defence should choose a team that takes into account language skills in order to effectively represent the defendant. Therefore, this defence team, these counsel have an ongoing affirmative duty to work with the other members of the defence team to pursue his or her client's interests. Defence counsel cannot use the translation issue to attack this court if they do not take reasonable measures to address translation needs. This charged person contends that the translation order seeks to shift the equality of arms by placing the burden of translation on the defence team and away from the state. The prosecution states far from it. The translation order provides them with a translator of their own choosing to fulfil any gap in language requirements, of which up until this date, 6 months after the order has passed, they have not accepted. And secondly, the translation order has invited the defence team to provide lists of documents they think they would like translated, and to this date they have not provided one list, one document for the CMS to translate. By providing a translator to each team, the co-investigating judges did not shift the burden, but they supplemented the defence existing linguistic capacity to further enhance the charged person's right to a fair trial. The defence had the ability to cooperate. Q Sampan's former and current lawyer speak Khmer and French, that's Mr Soibori and Mr Sarsavan. The charged person speaks French and understands, at least outside of the court, his ability to work in English through collaboration. I ask Your Honour to, for the shortness of time, I ask Your Honour to look at A190I4, ERN number 0022-1279. Perhaps if we can show it on the screen, but it's a record from the Paris Bar showing that Mr Vergès presents himself as a lawyer, an international lawyer that can work in the language of English. It doesn't necessarily state that he speaks English perfectly, but it shows that he can work in that language. Your Honours, I would ask that you refer to that in the case file. The charged person defence team also employs Mr Seng Sachita, who studied in France and speaks. The charged person's defence team also employs another Cambodian jurist, Mr Seng Sachita, who speaks French and Khmer and English. The defence team is comprised of other lawyers that speak the three languages. Your Honour, therefore, nothing prevents the charged person from requesting translation from CMS. However, over the past 6 months, as I've stated, not one translation has been requested. Your Honour, the translation order is not tailored for the defence, but it's aimed at all of the parties. The duty to collaborate in this judicial process is placed on all actors within the ECC. All parties are affected by not having some documents in their own native language, but they can ably and adequately cope by a process of collaboration. If Your Honours look at the screen now, you'll see the page for Mr Vergès from the Paris Bar, and he advertises himself as being able to work in English. Thank you. Your Honours, in a multilingual environment such as this court, we all have to be adaptable so we can meet our obligations in our respective tasks. Taking a conscious decision to opt out of a collaborative process, like this defence has chosen to do, has the effect of undermining their own clients' rights. Your Honours, I would like now to pass over the floor to my colleague who has 1 minute to close on behalf of the prosecution.
Thank you very much, Your Honours. This is what the co-prosecutors have already concluded, and it has taken enough time. And what I want finally is to request to the pretrial chamber our final conclusion, and I would like the pretrial chamber to reject the appeal of the defense counsel, because first, this appeal in the internal rule is not admissible. Number two, the rights of the charged person has not been violated or deprived of. And number three, there has not been any jurisprudence of international tribunals are subject to full translation for the defense counsel. So these are the 3 points the co-prosecutors would like to finally submit.
The President, defense co-lawyer, do you have any question? Mr. Sosavan. Thank you, Mr. President and the bench, and my respect to the members of the prosecution and members of the public. And I would like to request that the bench allow me to speak for 5 minutes. I think that I'm not going to speak up to 15 minutes, but I would like to make a few observations that we would like the translation of any documents that are used against my client, particularly the documents that are used in order to place my clients in provisional detention. So I would like to once again ask the bench to consider our request that we are urging that the documents concerning the provisional detention of my clients to be translated, because I know that they're based on certain document from a documentation center, and it was done very urgently. So once again, if we compare to the resources that the prosecutors have, is actually surpass what the defense has. So I think we are of the opinion that if we do not have any documents supporting the reasons for the provisional detention of my client, then we are not satisfied with what is being done now. And you may have already seen there is no decision on the appeal against the translation order. Then the co-investigating judges decide to extend for 1 more year of the provisional detention of my client. I think that they are playing around with this, and if we do not have the precise decision regarding this matter, I think that it is not fair for us. And once again, I would like to reiterate our position. We do not want any delay of the process because we don't want our clients to remain in detention. And once again, I would like to urge that the bench grant the appeal of the defense. And once again, if the pretrial chambers reject the appeal, I would like to remind the bench that on the 14th of February 2008, my learned colleague, Mr. Zach Vexes, requested or made a request to the co-investigating judges in order that they took necessary measures which is consistent with the investigation, and the co-investigating judges accepted the request. And at that time, the co-investigating judges did not order for the translation of the investigative acts conducted by the co-investigating judges. So once again, I think that this is a confusion, and the co-prosecutor has also mentioned that such a request is within the burden of the administration. And that time, Mr. Insri also requested for translation, and the co-investigating judges also accepted that. But what we feel sorry is that the co-investigating judge not only rejects the request for translation, but he also provides the obligation they impose the obligation on the requester for translation. I would like to bring up an example. For example, Mr. Kiew Samphan is alleged of certain crimes, and there is one witness. And I am the defense lawyer. I need to find other witnesses to prove that Mr. Kiew Samphan is elsewhere outside the crime scene, but I cannot find it if I cannot find those witnesses if I do not understand the inculpatory evidence. For example, if all the documents that are considered inculpatory evidence are not translated into the language that we understand, then we will not be able to defend the case. And once again, I come back to our issue. I would like to urge the pretrial chamber to consider as long as we, the defense lawyers, do not receive the document concerning the provisional detention of my client, then I believe that the trial is not fair for my client. And I would like to remind the co-prosecutors that we would like to cooperate with the co-prosecutor in order to find the truth. And if I don't want to change from black to white and white to black, and if my client was found guilty, and if there are enough evidence to prosecute my clients, I do not object to that. But I would like to once again urge that this court bring real justice to my client, and there must not be any interference from any political moves. And I would like to request the bench and the prosecutor once again to admit our appeal. Thank you.
Communiquer toutes les pièces à charge, bien sûr. Mais
Thank you. With respect to the exculpatio, we were told that it is in there. We are said ask for the documents. But how can we ask for the documents? How can we know for which documents to ask if they have not been translated? They are mocking us. They are saying, choose amongst the documents that you do not understand, those which you think are important. It's a joke. I think, let us now, I don't think that they're making fun of you, they're mocking you. I am not talking about written jurisprudence. I am talking based on my personal experience. I was present at the Milosevic trial, and the investigation took place in the trial. If a witness came to testify against him, the witness would come to the trial. We would see the witness at the trial. Milosevic would know 2 weeks before that the witness was going to appear. So for someone to use the case law of the international tribunals is different. We have a different system. We are working on the basis of a document that is drafted by a judge. We are told to work together. We're prepared to work together, but we need the means to do so. If we are being threatened with a punishment, then I will say that I am wearing a robe that gives me dignity, and I am not wearing the slippers of a servant, and I am no one's servant, and I fear no one. You wish to punish me, you wish to request sanctions, then feel free to do so, and do so immediately. And I will return to Paris, where my colleagues will applaud me for having stood with dignity based on what more was required. I laugh in the face of your threats.
Thank you, Mr. President. I would like only 1 minute to add, and I would like to respond to the co-prosecutors, the International Deputy Prosecutor. Because I look at everyone, I am now 68 years old, and I have been working in legal field for more than 30 years, both in France and in Cambodia. And I have never heard any judge ordered or advised the lawyers to do anything. This is the first time. On the 4th of December, the international co-prosecutors advised me to adheres to my obligation as the defense lawyer, and I would like to reiterate that even though I have been criticized by the prosecution, but I will not recommend anything to other parties. I don't know where he received his education in law.
The charged person, Mr. Kiew Samphan, please come to stand before the bench and make your final statement. Mr. Kiew Samphan, rise, please. Would you like to make any final statement?
Your Honors, my two defense lawyers have spoken on my behalf, and it is very clear that they need the translation of the documents in order that they can understand the cases before us. And I myself have reviewed the documents several times, and I have read a lot of books in my life. And I have been working for the sake of my country. I have been trying all my life to work for my country, for the independence of Cambodia. But now things turns out differently, and I am being charged of the crimes against humanity. Grave breaches. I do not understand why I am being charged of this, and I have written documents, and I have told the world what I have done in my recently published book. And I never understand why there are so many documents that implicate me of the crimes. And I have tried to understood what has happened. I asked even the detention guards, and they once told me that that's because I have written a lot of books so far, and there has been a lot of information about me. So I do not even understand the documents that are used against me, and I am still sick. I have not recovered, and I cannot speak clearly, and my thought process is not very clear as well. So if my two defense lawyers have the opportunity to understand the documents very well in my case file, then I will have all the confidence in them. And I believe that if they have the opportunity to defend me, then I would not be placed in provisional detention up to today.
The court is adjourned. The security guard please takes the charged person to the detention facility. Once again, the hearing is adjourned. I would also like to inform that the decision of this hearing will be notified at a later date.
Alo បាទខ្ញុំសូមជម្រាបតិចអ៊ំពូមីងដែលមកតាមឡានក្រុងបាទសូមអញ្ជើញទៅចាំនៅខាងឡានក្រុងបាទ